Lordship Bharat Chakravorti Das. Sir.
Good afternoon, ladies and gentlemen. I have great pleasure in introducing Justice Bharara Chakravorti, who is one of my gurus in mediation. When I heard Madam Laila Olapalli talking about the unassuming mediator of US, I immediately thought of Justice Bharara Chakravorti. He is an extremely good mediator and mediator trainer, but who is courteous to a fault. His erudition can be seen from the various articles authored by him, including in the mediation compendium published by the EMW. And I'm sure our audience, those who are attending this webinar, would be greatly enriched by listening to His Lordship Justice Bharara Chakravorti. Vanakkam. Over to Jyoti.
Now we have Mr. J.P. Singh, sir, on our panel. He is a well-known civil, commercial, and arbitration lawyer and also an accomplished mediator. He is the founder and organizing secretary of Samadhan, the Delhi High Court Mediation and Conciliation Center. He has received his training in India and also abroad in USA, where he has undergone TOT programs. He has been a part of the training programs for mediators held within India and abroad, and he has been appointed by the Mediation and Conciliation Committee of Supreme Court of India as an observer for several training programs. He has been associated with several workshops and given lectures on various subjects organized by several organizations and institutions, and he is the Secretary General of Madhyam International Council for Conflict Resolution. He is also the former Vice President of the Delhi High Court Bar Association. Welcome, sir. And over to Shirasti.
Shiraz, please unmute yourself.
Madam Iram Majid is a wonderful moderator of our previous session. Is a mediator and mediator trainer with 16 years experience. She is straddling the national and international fields and has many feathers on her very crowded cap. I invite you, madam, to the program.
May I take the opportunity to intervene for a minute and express heartfelt thanks to Justice Bharara Chakravorti for gracing this function with his presence. And we would request you, sir, to help us, the Keralas, and with more of your cooperation and symbiotic relationship in the years to come. May I also welcome Senior Advocate Mr. J.P. Singh for having taken the time to come to us. Thanks a lot. So let's begin with all gravity.
Thank you, sir. And good afternoon. A hearty welcome to the second session. I am happy and honored to be a moderator to such eminent personalities like Justice Bharara Chakravorti, Senior Advocate J.P. Singh, and our Iram Majid. If the first session was all about mediation, the second session is about mediators. The bulk of the mediators in India are either lawyers or judges trained by the MCPC, as we all know. And all these lawyers or judges are doing mediation part-time. Till date, mediation is not recognized as a profession in India. The All India dispute resolution rate is somewhere between 30 to 35% for mediation. And even though I hear that Samadhan, the Delhi Mediation Center, founded and chaired by Senior Advocate J.P. Singh, has a success rate of about 60%. Congratulations to you, sir. In India, the cases referred for mediation by courts is also abysmally low, 2.3 to 3%. We hope that with the passing of the mediation bill, things will change for the better and pre-litigation mediation will become the order of the day. Likewise, the standard of our mediators need to be improved. As mediators, we must be more professional, skilled, and effective in the Indian context. Most of the mediators in India do evaluative form of mediation. They seem to forget that mediation is party-centered, self-determinative, and voluntary. Most of us still do not practice what we have been taught. It is up to us, the mediators, to prove our mettle and earn the respect of the legal fraternity and the general public. We must also yearn to reach international standards and be recognized worldwide to make India a hub for international mediation. This is where today's subject becomes highly relevant to mediators, lawyers, judges, law students, and the general public. Before diving into the subject discussion, kindly note that I'll be putting individual questions to each one of the panelists, and you may explain to us your ideas and understanding of the matter in about 5 to 7 minutes time, because we are tight, because we have only 1.5 hours. And if anybody wants to add on to it, they will be given ample opportunity for the same, but always keeping an eye on the clock. Finally, I'll be putting a common question to all, and you may share a perception about it with us. Today, our subject is exploring the mediator's mindset, approach, and attitude in India, and comparing the same with international mediators. And let me start off with Justice Para Chakravorti from Chennai High Court. May I ask you, from your vast experience as a mediator first, then as a mediator trainer, and now adjudicating matters as a High Court judge, what do you feel is a primary difference in the mindset, approach, and attitude of a skilled mediator from that of a judge or lawyer who is appointed as a mediator who has not been given any training as such? Sir.
Okay. Before I answer, thank you, Kerala Mediation Conciliation Center. My memories go back to the times of Justice Srijagan, Justice Ramakrishnan. Even though Jawad and Uma were regular in all the trainings in Kerala, I was also there off and on. And I fondly remember those good times when we used to meet in person. Now, straight going back to the, at the outset, I want to place one thing on record. Now, Kerala was the pioneer in these tripartite meetings, where, you know, the member judge, the judge who is the member of the mediation committee will go to a district. They will have 3 sides of sittings. On the one side, all the mediators of the district will be there. On the opposite, all the presiding officers will be there. On the third side, all the members of the bar will be there, and there will be a discussion. This was a unique model, and Kerala was a pioneer in that. And that is how their mediation movement percolated to every district, every taluk. And that was a very important step for all the other states to emulate. So placing on record that even though mediation started in several other states, but this tripartite meeting, it was an indigenous model pioneered by Kerala. I congratulate the Kerala Mediation Center for that. And now I proceed to the question. Yes, it is a very important question in the context of the topic of discussion today. Now, considering the attitude of a trained mediator to that of a judge or an advocate, untrained judge or an advocate who approaches the mediation, I would divide this into 2. First, in the process of mediation. Second, regarding the outcome of the mediation. First, into the process of mediation as such. Let me start with the story. See, there was this Zen guru, and there was a very able Shishya who used to master every aspect of the rituals, aspect of the philosophies. He's a very pakka professional Shishya, and he felt that he has attained all the stages. And he went to his guru and said, "Guru, have I not attained liberation?" The guru said, "Yes, there is only one final stage for you. You go to this mountain, and there is this monkey which will be playing in the pool of stream. You just observe it for 2 days and come back, and then I'll tell you." This Shishya went to the mountain. It was a beautiful forest. In a valley, there was a spring pool, and he started observing the monkey. The monkey sat on the tree. It jumped from one branch to other. It took a odd dip in the pool. Then again it went. It scattered the flowers. It ate a little. You know, he thought. He kept on observing for 2 days and went back to his guru. And said, "Guru, I have now understood. The guru then asked, all right, whatever you understood of the monkey is you keep aside. Did you smell the flowers once? He said, no. Did you ever take a dip in that spring pool? He said, no. Did you taste that fruits? He said, no. Okay. The guru said, so long as you are a prisoner of your purpose, you will never attain the liberation. Now that is exactly the same situation here in mediation also. A lawyer as a judge approaches the mediation with the purpose of ending the litigation, effecting a compromise between the parties. They want the brief to be struck off from the rolls. So they are the prisoners of their purpose. That is the main difference between the attitude. No, I don't say that there is no purpose for the mediator. He also has a purpose, but that is very laterally broader. The mediator can go, a skilled mediator will go according to the theme.
Yes.
You heard Sriram sir saying that the chief secretary of Nagaland cried on account of the stress of his job. When any lawyer or a judge who approached that Assam Nagaland mediation would only go on the survey report or the border being demarcated. In a family matter, sometimes it will only go by the auditor's report. So a mediator is trained to go according to the theme. And the second more important difference in attitude is that a mediator renounces
Seems we lost the connection.
Yes.
Sir, I think there is some problem with the network.
So we can continue with the next speaker.
Yes, yes. So shall I move on to the next question?
I'm back.
Yes. Yes. Back. Yes. Back.
Yes, sir.
I'm finishing. Don't worry.
Yeah.
This is the first difference. A lawyer or a judge who is approaching mediation process as such, he will try to set the tenor, enforce his views, and then bring in his wisdom to give it to the parties so as to settle the matters.
Right.
Whereas an approach of the mediator will be going by the theme, sometimes empathize. He will take a odd dip in the pool also. That is regarding the process.
Yes.
Second, I'll take a little longer time for this question because
yes, sure.
the second is the outcome. Now, similar to the theories of economists, where they say this positive theory and normative theory, the judge or a lawyer wants the mediation should be more positive. That is their bar. How many cases out of 100, how many has been settled? What is the outcome? Whether it is enforced or not. Okay, they want it to be more positive. Whereas according to us, like purist mediators like us, mediation is more normative than positive. It has a value by itself. In one case where I was a mediator, it was relating to a society of some community. Now we referred it as a failed mediation to the court. But after a month or so, when I met one of those office bearers, he said, "Sir, before the mediation, it belongs to the same community. We used to go, our group will go to the same marriage, the opposite go to the same marriage, but we will make a call to the relatives and ensure that they have come and left. Thereafter, we'll go. But after the mediation, we are able to sit in the same row, even sit in the same, have food in the same row and eat. We'll say pranam and we are able to go." So this normative value is more valuable to a trained mediator, a skilled mediator, whereas that would be nothing from the viewpoint of a judge administering the mediation program or a judge who is approaching the mediation dispute. So this is regarding the outcome. Yeah, I would have settled the matter very quickly. The party would have come for some agreement, but I would be, as a skilled mediator, I would be more happy if the process has contributed something to the parties.
Yes.
That normative value is more valuable for me. So according to me, this is the difference both in the process as well as the outcome, in the attitude of a skilled mediator and a judge or a lawyer. And to very quickly to add a caveat, we are not here pronouncing A attitude is correct or B attitude is correct, but we are saying that when we are trying to understand in taking mediation to a next level, what we are saying is to improve it. It is necessary for all the stakeholders that these are the different approaches, these are the different attitudes in which the mediation can be approached. And I leave it to everyone to decide for themselves by reflecting on how should we approach mediation, how should we, because totally discarding the outcome will also be not good, but totally discarding the normative value will also be not good. So it is for us, every individual, to imbibe it in a proper context and to clear ourselves about the attitude required. Thank you, George, for this wonderful question. I think it's very important given the topic of the subject. Thank you.
Well explained, sir. I don't think anybody could have explained it better than this. You really put it in a very beautiful, concise way, and everybody understood it. Okay. So moving on to the next question to JP Singh, sir. We have seen phenomenal success of mediation in many countries. Do you feel that the slightly evaluative tendencies or the mediator's own beliefs, conditionings, and biases are the reasons for the lack of success in India? And if so, how can we equip the mediators in India with the right mindset and attitude to deal with both domestic and international disputes effectively? Sir.
George, let me take it forward from where Justice Bharata Chakravorti just now left. When we talk of success of mediation in other countries, we need to look at when did the idea of mediation take firm roots in that country. Types of mediations that are practiced, and culture and social expectations of the people. You have referred to the evaluative tendencies, beliefs, conditioning, and biases of mediators in India. See, when we considering mediation, it would be easy to assume, as Justice Chakravorti said, that the main purpose of mediation is to settle the dispute.
Yes.
While settling is one of the goals of mediation, the greater purpose of mediation is to enable the parties to fully understand their case and leave knowing what the best option or course of action is for their case.
Yes.
A good mediator can listen to the parties and see the main interest of the party beyond only the financial aspect and help each party understand this interest as a way to creatively settle the case. A good mediator will also understand that based on these interests, a settlement is not always possible. And helping the parties live with a stronger understanding of their case will enable the parties to make better decisions moving forward. So let's not get bogged down just by statistics to gauge success of mediation. See, the main types of mediation that are practiced are transformative, facilitative, and evaluative. The types or styles of mediation are most evident in the control that a mediator exerts over the process as the mediation proceeds. In India, for the moment, we practice facilitative mediation, where the mediators allow the parties to establish the conversation and the mediator only acts as a facilitator. In USA, the mediation practices began in the 1970s, while in India, mediation took firm roots in 2005-2006, when the court-annexed mediation centers were set up. We are relatively young, though it is referred to as an age-old procedure of dispute resolution rehearsed since Vedic periods in India. There is no empirical data so as to ascertain how it evolved over time in other countries. Results as I see, are very encouraging in metropolitan cities like Bangalore, Chennai, and Delhi, where it works two ways: by helping disputing parties to mutually resolve their disputes and also reducing burden of pending cases on the courts. So far as equipping our mediators to deal with disputes, both domestic and international, effectively, we need to understand culture, familiar negotiation concepts such as power, rights, and interests take on somewhat different meaning in different cultures. Global negotiations occur in multiple legal, political, social, and economic environments. When negotiators are from the same culture, ideology is the bedrock against which deals and decisions are made and disputes are resolved. When negotiators are from different cultures, each may rely upon different assumptions about social interaction, economic interests, legal requirements, and political realities. When we talk of international practices, we have to see how negotiation strategies practiced in different cultures and why and what the negotiator crossing cultural boundaries can do to modify a strategy so as to realize interests and maintain integrity, even when confronted with a very different cultural approach to negotiation. Jean Brett, in her book, Negotiating Globally, writes, we have a familiar culture model of individualism versus collectivism that is there in most international management books. Now, new research has discussed other three cultural types. Let me now bring that to your notice. Dignity culture characterizes familiar Western culture like USA. Face culture, which characterizes familiar East Asian culture like China. Honor culture characterizes culture which is prevalent in countries like Qatar. We have, trust issues in India, and with which we are so familiar while dealing with disputes in mediation. So our conditions are more complex, and a good mediator here can match, I think, the best across the globe. Jean writes that she is not convinced that there is likely to be a global negotiation culture anytime soon. Let's have good mediators, train them, groom them, and they will be of international standards. To me, what is important for a mediator's success, more than technical skills of how to run a mediation conference, is the ability to develop an empathic relationship with the disputants. This, to me, is the most important quality that a good, successful mediator must possess.
Thank you, sir. So according to you, this is a basic thing is about trust. The trust that the mediator develops amongst the parties and the mutual respect. And these two will carry forward this mediation a much longer and better, to a better level. Thank you, sir. Let us move on to the next question to Iram Majid. A mediator's mindset is focused on embedding the understanding of the conflict, and if the parties are having a different outlook in the potential outcome, what psychological strategies are followed by the mediator domestically and internationally?
Thank you so much, Mr. George, for asking this question. This is a very, very good question, in fact. But before answering this, first I would like to say thanks to KSMCC and the Kerala. So this place has given me a lot. And one thing I would like to say that I'm humbled and honored to be there with the part of the stellar panel, especially one is Justice and one is my own senior, from whose chamber I started my practice. And one thing I would like to say that JP sir is the one who introduced me into the mediation, and Anil sir is the one who is my mentor and who make me to understand mediation well. So today is the best day for me that my two seniors are there. One is in one section I was the moderator, in one section I am the speaker. So nothing can be better than this. So now coming to my answer. So of course you are right in saying that mediator's job is to show the parties the correct perspective of the fact, so as to help them to choose what is right. The parties will always create a different outlook based on their own perceptions and the perception of the fact. And it is often difficult to shift them from their perspective with the direct clarifying questions. So as you may run the risk of losing your neutrality. So this is where the mediator psychological strategies should become very, very useful. This is what I would be if you say nationally or internationally or domestically. So I would like to say that irrespective of any jurisdiction, the psychological strategies will be useful in every way. Because I would say that whatever the nature of the dispute, whether it is relationship or commercial or whatever the type of the disputants, whether domestic or international, the pattern in which the human connects with that dispute is almost same. So how we connect with our conflict, the pattern will be the same. So the disputes are mostly stored in subconscious of the brain, and the pattern in which we are storing the dispute is after deletion, distortion, and generalization of the fact. And while stored in the manner with the subconscious mind, it will be difficult for the parties to actually identify the real picture. They are themselves confused at what they are looking at, what is the interest and what is the position. And asking the right kind of question in the right manner to shift the dispute from the subconscious mind level to the conscious level is the soft key, or is the soft skill strategy employed by the mediator. Then only we can bring the dispute to the conscious level where the parties will be having maximum option, maximum choices, and the correct information. See, when the conflict will be stored in your subconscious mind, you will be adding your perception, you will be deleting some facts, you will be making the generalization of that event, and that event which happened will not be the same. It's a distorted event, and the parties will be talking again and again of the distorted event. And it is very difficult. Why? Because there will be minimum options, minimum choices, and incorrect information for the mediator. So you have to bring parties from the subconscious level to the conscious level to give them the maximum choices, to make them understand why they are here, what is the interest. And the parties keep on repeating their structure, which is there in the subconscious. So what mediator has to do? Mediator, see, let's say party A and party B. Party A has a structure of the conflict in circle, and party B will be having the structure of the conflict in square. And the mediator can see the circle and the square in subconscious mind of two parties. So you have to go to the subconscious mind. You have to take out the structure. You have to dismantle that, and you have to place on the table before the parties as a plain figure. So the mediation would look easy when the parties are in the phase, but mostly mediation fails because of the mediators fail in bringing the parties to the right stage, and before they try to resolve the dispute, they put into the that stage. So mediator should know the psychology of mediation and physiology of skills of bringing both the parties' perception together. Many techniques are there. I will say that hypnotic language, use of psychology, use of NLP techniques, meta models, and meta programming, by which you can bring and you can understand the mediation psychology, because it's more about the psychology in the subconscious mind. This is what I would like to say. These are the techniques or the psychological techniques which you can use irrespective of any jurisdiction.
So, according to me, even the litigant might not be aware of exactly how the dispute occurred or where the conflict started. It will be covered in so many other slices and things all that. So you have to peel like peeling an onion. You have to peel off all these other.
I would like to say one thing. That is why, if you are a good mediator, you can be a good litigation also, because you can understand why the parties are here. You can understand at the same time the structure of the conflict and what is the thing which you have to take out, so that there should be a fundamental justice should be given to the parties, not the institutional justice.
Once you find out that pin, the thorn, everything can be easily solved. Yes. Thank you. So we go to the next question, that is in continuation, JP Singh sir, in continuation to the first question that we asked. We are all aware that mediation has played a fruitful role in resolving many international conflicts, but we have also seen instances where mediation has utterly failed due to many inherent lacunas. When we talk about international practice, how do you think we could improve the quality of mediators in India to accept international challenges?
George, this question brings me back to the answer I gave to your earlier question.
Yes.
I told you that we are practicing facilitative mediation. Facilitative mediation gives parties more freedom to be creative and find ways to bring their ideas closer to the settlement. Here, the mediator controls the process of mediation, but parties control the outcome. As I said, reaching a definitive agreement is not the primary objective, although it is a secondary goal, and usually the natural result of the involvement of an effective mediator. Why do I say so? Because mediation sometimes resolves disputes, sometimes it contains them, and sometimes it defines them more clearly to the parties. As Aram said, it is sometimes in their mind. You have to clearly spell it out. And this is what facilitative mediation does. So we need not get bogged down only in, as Justice Chakravorti said, only in the issue of settlement or the outcome. Mediation may even serve as a gateway to self-awareness, empowerment, forgiveness, and reconciliation. Even if there is no definitive agreement, always, however, mediation provides the opportunity for making better decisions, even only if it be the decision to submit the dispute to a court, the boss, an international tribunal, or other authoritative decision maker. Now, let me give you an instance what happened in one of the matters under the Commercial Codes Act, which we call pre-institution mediation. That matter was referred to the center, and since I was appointed as the mediator, parties were able to actually, talk about a lot of things on the quantum of the claims, etc., but they got stuck on interpretation of a clause of a contract. Now, as a mediator, I cannot give them that answer. So, what was the settlement? They agreed to go for that interpretation to an arbitrator. So this is a way a dispute can get resolved. And because they found, instead of going to court and spending years in court, they said, let's go to an arbitrator and get this issue decided. And it expedited the whole matter. In this sense, to say that mediation failed may not be a correct perspective. Being a process, it never fails. We have come to believe that mediation's greatest value lies in its potential not only to find solutions to people's problems, but to change people themselves for the better in the very midst of the conflict. Time and again, we have seen people change in small but significant ways through their participation in this process. Now, so far as the improvement of quality of our mediators, I feel the sheer numbers of our population and the number of cases filed and pursued in courts is a reservoir for the mediators to hone their skills. Mediators have a responsibility to improve and maintain their professional skills, attend as many trainings and workshops on mediation as possible, educate themselves by reading material on mediation. It is a process of continuous learning.
Yes.
We have a great opportunity of sharpening our skills being part of court annex mediation centers. It is a great opportunity for us to use and practice our mediation skills in the pending matters which are being referred for mediation. These numbers are not available anywhere abroad. So use this opportunity made available by the courts to become better. Opportunity in future to be hired as a private mediators are very bright. As was said, let the market forces decide. Now, so far as the cultural aspect, see, Indian society is collectivist in that it promotes interdependence and cooperation with the family, forming the focal point of the social structure. Though our joint family structure is changing with rise of nuclear family and the extended family system, culturally, we are already equipped to follow a collaborative approach. In Hofstede's model in terms of uncertainty avoidance, Indian society scores 40. Now, it is a modest score. We have acceptance of imperfection, unfortunately. Nothing has to be perfect, nor has to go exactly as planned.
Okay.
It is this attitude that is both the cause of misery as well as the most empowering aspect of our country. There is a saying that nothing is impossible in India, so long as one knows how to adjust. This chalta hai attitude must go. In case we have to compete against the best globally, we have to structure or strive for perfection and have to go exactly how we have planned and according to the rules of the game. You see, we as mediators need to improve our own negotiation and communication skills. And therefore, what we need to practice are those 3 P's: practice, patience, and perseverance. In words of Kathy Domenici, success is attained when a mediator uses effective communication techniques to facilitate a process where individuals become more cooperative negotiators. So that is what will measure success for us. Thank you.
Yes. So I fully agree, sir, because the court-annexed mediators have the best opportunity to get the maximum number of cases to be mediated. So much cases are coming to us, and we get the maximum opportunity and the best opportunity. So it is up to the mediators themselves to improve themselves. The self-improvement is the name of the game.
Exactly.
So let's move on to the next question, that is to Justice Bharara Chakravorti. Even though court-annexed mediations are outside the scope of Singapore Convention, we heard a lot of talk about Singapore Convention in the first session. Should we not equip the court-annexed mediators also with the right mindset attitude to deal with international disputes and foreign citizens while doing mediations in court-referred matters? In such case, what do you think the focus should be on?
See, regarding Singapore Convention, it is essential for every court-annexed mediator also to understand the basics. The simple filter which the Singapore Convention employs is that first it relates to, like, international mediation is defined as where the business is in more than one jurisdiction. So firstly, we have to understand that it relates to commercial matters, number 1. Number 2, any dispute which which is mediated and is recorded by way of a court order is excluded. So therefore, that becomes very important, because even just before my elevation, we had a mediation where, you know, it was relating to a dispute regarding trademarks. They had 78 oppositions in 17 jurisdictions, and they settled. And one party had to withdraw the oppositions in for some marks, and the other. It's a group of companies, so they divided the marks between them. So as a mediator who was not very well versed with the Singapore Convention, I recorded everything in my agreement. Now, had I been better informed about the Singapore Convention, I could have just guided the parties to keep away the separate clauses regarding convention countries by way of a private agreement between them, which is not part of this court recorded agreement, because it was enforceable easily by virtue of the Singapore Convention in the convention countries. So that is one thing. So even when you are dealing with only court annexed dispute and your agreement is going to be recorded in court, which will be outside the purview of this thing. But more often than not, there is a foreign element in many of the cases, and the importance to enforce this settlement agreement would also come. Therefore, it is very basic for any mediator, whether he does court annexed mediation or private mediation, to have the basic knowledge of what the Singapore Convention is all about, whether the dispute touches about the international mediation as defined under the convention, and whether it involves enforcement in any convention countries. That would help a long way. Like when we help the parties in drafting out the settlements to enforce it in better manner. When we in the same way, this is also like in respect of court fee, in respect of affecting partitions, in respect of paying stamp duties, where, you know, sometimes the mediators also help assist the parties in coming into better terms, framing better agreements. So the basic knowledge of Singapore Convention and its effect worldwide is to be understood. And please also, like taking forward from what JP sir said, like I myself, we had an arbitration before WIPO, before my elevation. It was relating to an internet domain website. An arbitrator from New Zealand was the arbitrator. And then we were appearing for the respondent, and we had prepared everything, every counter, everything ready one day before. Lethargically, I was just, okay, today is the last date, all right. And after coming from court, I just uploaded and emailed it. 10 minutes, Pat came the reply. Your counter affidavit is delayed by 1 hour, 14 minutes and 28 seconds, hence rejected. Okay. So it is this kind of an approach which when as mediators, if we don't follow the mandatory procedures and make it appear that these procedures are also being followed, now the country which is going to enforce these settlements will not enforce. So that is one thing which the mediators have to keep in mind. And second thing is to understand the basics and know the basics about the Singapore Convention. These are the two things I thought, George, for any court annex mediator to understand when it comes to international mediation. Thank you.
So it is imperative that all mediators in India must have the basic awareness about the Singapore Convention and how these things are done at the international level, which will help them a long way in resolving these disputes, and especially when international parties are involved. Thank you. So we go to the next question to Ram Majid. As part of effective implementation of mediation process, most of the trained mediators are skilled with verbal mediation techniques, but are mostly unfamiliar with non-verbal dimension. From your experience in international and cross-border mediation, can you enlighten us about the importance of para-linguistic approaches for a mediator for effective process management? I think this is a very important question.
Yeah, this is a very important question, and thank you for asking me this. And I'll connect it with what JP sir has mentioned about the cross-culture. So when we talk about the cross-border mediation, the major hurdles that is faced by the mediator is not about the nature of dispute, but the cross-culture of the parties. In India, even though we are having multicultural society, and even though we have numerous languages, we have seen the non-verbal language synchronization is more or less same, but in India. But if it is completely different when we venture into cross-border mediation, as there the difference is not only in the culture, but differences in non-verbal aspects as well. The mediator has to take into consideration the differences, what JP sir has mentioned about the societies like the collectivism and all. So I will be taking it further, because the differences of the high context society, low context society, low individualism, high individualism approach. There are also difference between the high power distance and the low power distance, high certainty avoidance, low certainty avoidance. So understanding these differences would determine the process is taken forward, and also determines that how the mediator should commence the process. So right from the meeting and greeting, the tactics change. Even the drinks, beverages, or the food you serve during the mediation will also become very, very critical. So the emphasis on the culture become very crucial. It is like a boxing ring. See, unless you get inside the ring, how can you expect to start the fighting? So for the mediator to start employing his mediation practice to resolve the dispute, he should first enter into the mediation process with absolute confidence to both sides. And I would like to say that there are some common techniques which you can use irrespective of any jurisdiction. And those techniques are in the non-verbal communication in all cultures are the mirroring, matching, and pacing. So when I do my mediation, generally when I'm unable to connect with the parties in different ways, so I use these techniques. These are the non-verbal techniques: mirroring, matching, and pacing. The mirroring and matching is the connect which happens at the neurological level. So once you will be connecting with the parties at the neurological level, see when the parties are coming, so you and parties, you will be making, will be on the different points, A and B, suppose. So you have to connect the parties at some level. So you have to make a V that is called the internal V. Internal V is very, very important to create while doing the mediation, so that you can connect with the parties at one point. Then only they will tell you entire confidential and entire thing. So for that, you need to connect with the parties. If not with the verbal, then the non-verbal techniques. And the techniques which I told you is the mirroring, matching, and pacing. If you mirror the parties, if you match with them, if you pace with them, 100% I'm sure that you can lead them thereafter. So whereby you can gain the trust, rapport, and liking of the other parties. So this is what from my side regarding the para-linguistic approach and non-verbal techniques. See, we need to be trained into all these techniques, that how you can mirror the parties, how you can understand them well, how you can create an internal V. And if internal V you're unable to create, then you can create an A. So you will be polar parts. So you have to understand those things, and we have different techniques. And if somebody wants to know more mirroring, matching, and pacing, they can ask me in the question. So I will be happy to answer that. So over to you, George.
See, I hope that as moderator, I have mirrored you to a certain extent.
You have mirrored more than what I demonstrated. Yeah.
I understood you very well. So the next question goes to Justice Bharara Chakravorti, sir. In cases of many court-referred mediation, parties often agree to mediate, not because they want to resolve the dispute by mediation, but due to compulsion. As a mediator for a long time, I'm sure that you're very familiar with this. It can also be seen that in such cases, parties does not cooperate with the mediation process, and the matter will usually be sent back to court. How do you think the mediators in such compulsorily referred matters change the mind of the parties? Is there any way?
Yes. Yes, let us understand that as opposed to both sides consent, no law has been settled. Now that the court by itself or even one party opposes, we can refer matters to mediation. Now under this scenario, as you put it, that the parties will be reluctant, and from the moment they enter the mediation center, they will be interested in winding up or closing this process and run back.
Yes.
Now this happens like that again. That is why JP sir explained this process. Like as mediators, we have to be adept with this. We have to be alive to this problem. Therefore, apart from facilitative mediation, we have to be conscious of the fact about the transformative mediation, where we have to speak about the empowerment of the parties. We have this negative spiraling and positive spiraling theory given by Bush and Folger. So time has come for us, to move just beyond the while sticking to the core to the facilitative mediation. There are enough number of tools in our armory, such as the empowerment in the transformative mediation, sometimes starting off with a separate session also, and in an evaluative mood also. And as you said, that it is because of because we have to understand, like what you said, is that there is a lack of trust or the cultural moorings which every case will by itself bring to the mediation table. So unless we are alive to that situation, now we can still make the parties to attempt mediation. Like even a most unwilling party, we can say by saying that you ask what you want, if the other side may accept also. So like we have to go according to the theme which is there in the parties, and therefore see the socio-economic background of the parties, the circumstances in which the party is averse to mediation. Like they, as you said, that even the litigant will be looking at about the positive. This man is not going to settle. Why should I waste the time? So he is only focused about the outcome. We have to explain then the process itself has its own benefits. Therefore, the opening statement can be a more elaborate opening statement can be the key. then involving sometimes the other parties who are standing outside the mediation room, sometimes, who are not the parties to the conflict. So these kind of techniques which the mediator has would, in my opinion, make the parties even to attempt the mediation. As usual, like what we say is that we have to make, as mediators, we have to keep, like follow the 3 P's as said by JP Singh, and we have to put our best foot forward to make the parties even to attempt the mediation, in spite of which they are not then it's good. We are not to be blamed. So it happens in once in a while. But to my knowledge, even a reluctant party, and if we are to add to the rate of success, I think the mediations in India, we are able to make them to sit in the mediation table at least. Or even in an odd case, we are able to, take the proposals back and forth by having a separate sessions. And in no case it is of zero value or useless, according to me, as a mediator, more so. So therefore, I would conclude by saying that even if the party is unwilling at the outset, now that is on the mediator, like a friend who's welcoming inside the house, to adopt his own technique depending on the situation, so as to make the party to undergo the process in good faith in an open manner. That is all can happen. It can happen in any manner. Like in one case where we said the parties were Muslims, they were not even willing to talk. Somehow it so happened that it was Ramzan month, and the time for praying had come in between. Therefore, we were just discussing that this mediation would help. And then even when the opening statement was made, the time had come, then we had to go out. They had their prayers. And after the prayer, he gets up and says, okay, it came from your mouth that just before my prayers, I think there is some message sent to me. And then he immediately said, so anything can happen in the mediation. All that is that you change the tenor, you change the atmosphere. As a mediator, the way in which we welcome, the way in which we open our first sentence should calm them down. And if we have that basic technique right, even an unwilling party, to an extent, I'm saying, I'm not saying in all cases, at least in 90% of the cases, we must be able to make them to undergo the process in the true sense.
Yes. Understood. Thing is, I've heard somewhere that the best negotiation strategy is to first agree to their side, as if we are on their side, and then they will slowly come to us, and then we can slowly divert it to the way we want it. Likewise, as you said, to empower them, to support them, and make them feel that there is something you're going to gain from this place, from this mediation, they might turn around. Thank you.
And I just wanted to add a thing about the previous question. I'm sorry. Like when we formulated this syllabus for this ODR, now we bumped on this initial chat mediation and thereafter this email mediation. Now most of our mediations were only oral, and we end our mediations with the oral exercise itself. But in the email mediations, I found several writings, like there were so many standard questions which were framed, and this email to parties, in what manner you want the mediator to understand. Now, how do you think that the mediation has progressed? There is a standard set of questions. I will even share that. When we had this ODR, we were putting our head in framing this ODR syllabus for the training. We bumped on this after the chat mediation, this email mediations. Now, world over, there has been very beautifully, they have framed these questions. And in one of my mediations, in online mediations, it was not going on. It was ultimately, there was an impasse. Then I employed this. I will write an email to you all, to both. It was a family mediation only. So the 10 standard questions I sent to both of them, and I asked them to write answers for each of the questions. And then they emailed me back. That at least opened the gate for further discussion. It helped. Therefore, normally when I thought I'll add that to the question. Like in writing mediations also, as she put it, some parties this thing from the cultures where they come from, and they will write, they will like it more in writing also. So we have to be aware of that also. Even in the present context, a reluctant party also, we can say that I'll send a mail, you answer to me, and then we will sit orally also. So if the party is reluctant to sit and discuss across the table, that I found out, and I had not used it in all these years of mediation. Recently, when we are trained in the ODR process, that was a new learning, and I tried to employ it immediately in one of my mediations. So I thought I'll add that to Iram's this thing. I'll try to circulate this to Pankaj sir or yourself, those questions, so that it can be dispersed in that WhatsApp group or whatever manner possible, in the conference note also, so that it can be circulated to the mediators. I'm not saying that those are the only questions, but we can have an idea how they frame those questions, and non-verbal mediations are going on also.
Yes.
Thank you.
So please circulate it to Pankaj itself. He will circulate it to all of us, and we'll be grateful for that to you. And according to you, I think what I understood from your answer was that we have to be creative in our strategy to see that there is a difference in their perception about mediation and how to participate in the mediation process. So we're coming on to the next question, that is to JP Singh sir. And I think you're the best person to answer this with your vast experience in the mediation field and the Samadhan and everything. Do you think we need to have specialized advanced training for the mediators in India for having specific approach, mindset, and attitude to deal with different types of cases, so that they could be well equipped to cater to different types of disputes? For example, approach and mindset of a mediator will be different in a matrimonial dispute as compared to a commercial dispute or an international dispute.
Thank you, George. To answer this question, let me put you into that, Iram's boxing ring, and then answer it for you. See, mediators have a duty to know the limits of their ability.
Yes.
To avoid taking on assignments, they are not equipped to handle. And to communicate candidly with the parties about their background and experience.
Yes.
Sometimes parties want a mediator with subject matter expertise, for example, divorce, company disputes, property matters, matters under ERA, consumer disputes, and the like. Or a particular set of process skills like multi-party negotiation. Let parties decide after mediator discloses his degree of competence. Sometimes we get chosen to handle an assignment where we lack competence. Parties, having heard of our protestations, may still want us to continue, but we need to be very clear. See, sometimes when you do not have the requisite skills and experience, you can make matters worse. Yes. As Iram said, we can become an A. You can mirror the, we as an A. Now, as taking it forward from what Justice Chakravorti said about transformation, to be sure, there are circumstances in mediation, as in medicine, where the problem may have to get worse before it can get better. Venting emotions can be a very painful process. Before employing this technique, however, the mediator must be confident that he has the skill and the experience to avoid making matters worse. Now, how do we do it in Delhi? See, in Delhi, this is done by having a preliminary workshop, whereafter the participants sit as a co-mediator with an experienced mediator. After participating in 10 successful mediations, so that it can, it nearly be a year, and you may be doing 25 or 30 mediations to get those 10 successful mediations, they attend an advanced workshop, whereafter they handle mediations on their own. There is another refresher course after they have mediated in 10 successful mediations. This gives an opportunity to them to correct their shortcomings in controlling the process by self-critique and coaching through the role plays, which is done by the other mediators there. Now, so far as the proponents of the process knowledge feel that mediation is meant to support the parties in their making voluntary decisions together, and that the parties are fully informed about whatever they may find relevant to the decisions they will be making. In that sense, they feel that the process need not be dominated by the law. They feel in most mediations, a party doesn't even need a lawyer's direct participation. Parties who are mediating are less likely to need an advocate because they are trying to work together to solve their problem and not trying to convince a judge or an arbitrator of their point of view. So this is their view. In mediation, parties should understand the legal implications of their case, but the law should not direct mediation. At the core of mediation, the mediation puts as much weight on personal, practical, and business-related aspects of any conflict as on the legal aspect. But let me tell you, the process knowledge, however, is different from the substantive knowledge one may want in a mediator. There are disputes which require specific domain knowledge as well. Now, let me give you an example of like medical negligence cases, where doctors can play an important role. Suit for dissolution of partnership and of accounts. Chartered accountants' help can be taken. Construction disputes, architects and engineers can be equally effective.
Yes.
Family disputes, as you said, knowledge of Hindu law, Muslim law is so important. Counselors, psychologists also have a role to play here. Now, this brings us to the concept of co-mediation. Co-mediation can improve the quality of outcomes. Co-mediation is a mediation involving multiple mediators, especially usually two, who may in some way complement each other by gender, personality, culture, professional background, or other ways, in a manner that can improve the quality of both of mediation process and its outcome. Now, as a domain expert co-mediator with their training or experience in resolving certain types of disputes, they bring specific skills to mediation. Domain knowledge such as industry, scientific, medical, or technical expertise can make a difference to the outcome of mediation. But here also comes the role of the lawyers who participate in the mediation process. They can advise on the law relevant to the dispute and assist parties in reviewing the terms of settlement so that they do not fall foul of the law. So therefore, lawyers and mediators have to play a complementary role here. And as you said, you can improve the quality of outcomes by bringing in a co-mediator who has the definite skill knowledge in that subject.
Let me add to that, because I feel that there are some mediators who are good at handling emotions, who are good at doing family mediation. But some mediators do not like to do family mediation. They try to avoid that. They do more commercial type of mediations. And that kind of differences are there amongst the mediators.
George, handling emotions is not an easy issue.
Yes.
And especially in matrimonial mediations, people are full of emotions. And unless you deal with those emotions, the substantive conflict or dispute will never be resolved.
Yes. So, talking about mediation, this emotion, the next question is to Ram Majid, and it deals with how to deal with the extreme emotions of parties. When, particularly in family matters, what mindset should a mediator be in to effectively handle emotions of the parties and themselves under stress? How can mediators understand whether they have an accurate perception of emotions of their clients and whether they have succeeded in managing it?
Very technical and emotional question to me. I'm an emotional person and emotions are very close to my heart. So thank you for this question. And this is very, 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 very important, how to deal with the emotions. And I think we could have a separate session on that also, but I would like to give the justice with the question. I would like to explain a little bit what, as per my knowledge about the emotions. See, emotions handling is something which is very, very crucial because in any negotiation or mediation, there are two things. One is substance and another thing is emotions. You can deal with the substance very easily, and directly. But if you have to deal with the emotions, you cannot deal directly. Many places you may read in very many YouTube videos and all. If you feel something, go and ask directly. See, that is the wrong thing. Beware of touching emotions directly. If you will be touching emotion directly, there may be disaster. So emotions are something which is personal to a very, very personal stuff. You should not deal with directly. So I would like to start with there was a survey conducted in the New York about these things. So what they said, okay, they called couples there and they said, either you are married or unmarried, you should come here. And in that room, you have to be there for 20 minutes. You have to discussion with your spouse or with your other better half or your girlfriend or boyfriend and with the person, and you have to be there for 20 minutes. And with that conversation, they will be telling you that whether this relation is going to be last down the line, it is going to be end in 10 years, 8 years, 2 years or 3 years. And they fix all the cameras over there. There were two types of camera. One camera which was, taking the broader view of your body language, and another camera which is the micro level camera, which was reading your even small muscle twitching and all that body language. So down the line, the discussion happened and the couples come out and the survey was 96% correct and accurate. So if anybody wants to answer from the participant, from the in the chat box, they can write that what was the thing which those people they took out from that discussion. Anything you would like to add to this? Any participant can write down in the chat box that what was the thing they were looking at and what was the thing they were reading in that conversation which happened inside the room. Any answer?
Yeah, thing is, my experience is when I handle this family matters and the lady starts to cry, I am really lost. I feel lost. Then I'll give her
so
time.
Somebody has mentioned compatibility.
See, I cannot handle lady crying for no.
Think more about it. What was the thing which the people who are conducting the survey, they are looking at with the conversation in those people? See, we have to think more. Compatibility. What else? I could not get an answer from the participants. Subconscious mindset. Anything else?
Yeah, then I wait for her to subside, the storm to subside, the emotion to subside.
Leaving ego.
Okay. Then after they have let it out, they'll be much more calm. And then we can continue with the mediation.
See, the one who will give the answer, send the address also, I will send the chocolates. But I need answer. You have to do brainstorming and think about it, that what was the thing they were reading, emotions. So let me answer this because I understand that time is very crucial in this.
Yeah, that's right.
So the answer is that how they are appreciating each other, the way they are appreciating each other. See, that was the thing they were reading. And the moment, it's not 20 minutes they required, only just 5-minute conversation with the couple or with the person to whom they are standing. Within 5 minutes, they can read that whether this relationship's gonna last for how many years or days or whatever it is. So it is what I would like to tell you, that the most important thing in relationship is appreciation. So there are few core concerns which I would like to tell you. When you are dealing with the emotions, you have to understand these 5 core concerns. The one is appreciation. You have to appreciate the clients. You have to appreciate the parties. See, feeling unappreciated put the people down. We can appreciate others, find merit in their point and what they think, what they feel, how they communicate and what they understood. So express your appreciation towards them. Expression of appreciation doesn't mean that you are agreeing with them, but you have to show your appreciation. That will ease and make party very, very comfortable. And it's a process of, handling the emotion. It's not direct, but through a core concern. So first is appreciation. Second, I would like to tell you about the affiliation. See, we need to bring structural connection, and also affiliation with the parties to make the session or mediation very smooth. And for that, we have to build a rapport through making affiliation. So this is what we said: connect, talk, and walk together. So build affiliation. Third is role, making your role very, very fulfilling. You have to give respect to their conventional role. You have to give respect to their temporary role. Maybe I'm mediator here. This is my role. So how I can make my role fulfilling? So choose fulfilling role. You have to make your role fulfilling. And status. This is something which we might make mistakes there. So use the status to stimulate the positive emotions and don't judge them based on the status. Acknowledge their status. Another thing is autonomy. So autonomy, I will not say ABCD, I will say ACBD. Always consult before deciding. So don't impinge upon their autonomy and try to expand that autonomy, and respect the autonomy. So these are the 5 core concerns. If you want to remember this on the 5 finger of your hand, so you can even remember with the 5 finger: appreciation, autonomy, affiliation, role, status. See, these are the things which you have to filter the emotion first and then deal with them. See, I could tell you one of the case which I was doing in the mediation center with as a co-mediator. So there was a case where the parties came and husband was the Muslim guy and the girl was, she was from other religion, and they were a business partner. They were doing a business. So then they fall in love and they into the marriage, they formed a marriage. And then after, what happened that they had a baby boy, and all 3 converted into the faith of girl, and they all converted into that religion. And after some time, I think 2-3 years down the line, the boy said, I want to convert into my own religion. And he again converted back to the Islamic religion. See, that was the problem when they came before the mediation center. There were 2 things. One is the substance and one is the emotion. So this dispute has a commercial angle also and the emotional angle also. And when it was the commercial, because they were the business partner, it was very easy to decide. Very, very easy to decide within 2-3 meetings. But when it comes to the emotional aspect, that what will be the religion of the child, who will acquire the status of the guardian of the child, and how child will be brought up. So that was the crucial issue, and the parties took longer time to decide that. Why? Because emotions are very, very personal. You cannot deal it directly. You have to be very, very careful because you are entering into the intimate zone of the parties. So whether you are in the same rapport, whether you are having the same neurological connect with the parties before entering into the personal zone, you're entering into the personal zone. You can't touch those wires unless you will be comfortable and the parties accept you to enter into their comfort zone or their intimate zone. So you have to be very, very careful while dealing with the emotions. These 5 core concerns I told you is the best way to deal with the emotions. And I am very emotional about it. Yeah, over to you, Joseph.
So if you cannot handle emotions properly, you cannot be a good mediator. If you want to be a good mediator, you have to know how to handle emotions of all kinds. Okay, the next question goes to Justice Bharara Chakravorti. Sometimes the counsels who represent parties are also skilled mediators, but they often do not cooperate with the mediator when they are appearing in their capacity as a counsel. At the same time, when they act as mediators, they expect counsels to cooperate with them. How can we bring about a change in the attitude, approach, and mindset of these advocates who are also mediators to get maximum cooperation out of them? And I'm sure that Justice have faced it when you were a mediator.
I am guilty of the complaint. See, in the initial years of mediation, because I learned mediation that it is a party-centric process. Therefore, I will call my party. See, it is all in your court. You go have a ball in the mediation room, and I will not interfere in any manner at all. That was my attitude, which was also wrong. So the key is that you can be a mediator. Your role as a mediator is different from your role as a lawyer to the party in the litigation and as a lawyer to the party and a lawyer assisting the party in mediation. We have to understand these three different roles. And then, you should neither wash off your hands nor interfere in the decision of the parties. But there are advocates who are guilty of both. And then there are the third persons who are very over enthusiastic and always ask their party to come to the point without even knowing what is the point. In a partition suit, a brother will say that I have pedaled my other brother to college for 5 kilometers every day, which is a very valid point for mediation. The lawyer will immediately say, no, don't talk all about, sir. You purchased that property in the year 1985. Are you willing to give 50% to the other brother or not? So they will come to the point not knowing that what is the point. These are the three things. So the most important thing, I am saying that in a good faith itself, in good faith itself, we commit these three mistakes. First one is that we don't understand our role as a lawyer under, assisting the party in litigation is different from a party assisting a party in mediation.
Yes.
We don't understand that our role as a mediator is quite different from the role when you appear as a party, the lawyer for the party. As a lawyer for the party, as one of those webinars, Jawad had very nicely put it about that getting to yes. So we have to have a session with our party in empowering him to get the other party to yes. So we have to have a very different session with our parties. That is, we have to prepare our parties in the context of negotiation rather than, feeding him with all kinds of good point that you have a very good case. You tell this, you tell that. No, that is not what we should have. So we should first have a session with our parties, but in a different context of getting to yes, rather than, making him to win. That is the difference which is thing. So that is number one. Number two, we can always accompany our parties and take a back seat. No to take a back seat.
Okay.
When Iram ji spoke about, when the mediator is handling with the emotions, you have to take a back seat and be a fly on the wall when the emotions flow. And then third, assist only when it comes in framing better agreements and the things. So this is the primary of a role when you assist the parties. And we are guilty in either not preparing them or going inside the mediation room and taking up the mantle of the mediator because we are a trained mediators. You don't even have the patience to listen to the opening statement when your colleague makes it. When you makes it, you want the other parties to listen to it just because that is not for you. That's for the parties. You don't cut short by saying, I myself, I am a mediator. I have explained all this to the party. You can go ahead with them. No, that should not be the approach. So the process and mediator is in control of the process. There you should not enter. The outcome. That is, the parties are in the self-determination. There also you should not step. Now you are in between. You are in between. You have to, better equip the party to negotiate and assist them subtly. Certainly your presence is a very valid value addition to the mediation process. It is not that like my attitude to keep my hands off was also wrong. My erroneous understanding about my role as a party's counsel. And the general prevalent attitude to come and take the front seat and argue the matter in the mediation center is also wrong. And therefore the difference of your role. Like Kerala has taken a very good initiative in giving them the training as a counsel in mediation. That is the key.
Yes.
Therefore, even as a mediator, I should undergo that. Not just because I am an expert mediator or an expert trainer, that doesn't mean that I should not take that training as a counsel assisting the parties.
Yes.
Which is a very different role.
Well put, sir. Is actually Kerala, we have this mediation advocacy courses for advocates. And we have taken awareness classes for advocates at all districts. So it is bringing about a huge change in the attitude of the advocates. So the next question, the last question to JP Singh, sir. There are many mediators in India, but most of them are practicing part-time and not seen much in international arena. What do you think is lacking in India to make mediation a standalone and attractive profession like in many other countries?
George, having heard others, I feel that we seem to be in a hurry.
Yes, I'm running out of time. I'm running out of time.
No, I'm saying I'm on the question of part-time and full-time and remuneration. We are in a hurry to make mediation as a profession which would be as remunerative as the adversarial process we practice in courts. Let's understand. Mediation as an institutionalized process is relatively new in India. There is lack of awareness amongst the disputants about benefits of mediation. Thereby, every dispute is taken to the existing legal system, that is courts. Now, mediation is a different skill. A good litigator need not be a good mediator. The skill sets of a mediator are totally different. Till it becomes a preferred mode of dispute resolution and parties opt for it before approaching the courts, it will not be equally remunerative as litigation practice. Therefore, practice of part-time mediators today. The phenomenal success in court annex centers is on account of litigation fatigue, delays, exorbitant costs. Till pre-litigation or private mediation becomes the norm, it is difficult to see full-time mediation practice flourishing in India. There has to be a change in mindset. Lawyers feel that if you recommend mediation to your client, he would think that you have a weak case. This is the mindset from which we work. So far as remuneration, abroad is concerned, let me tell you my own experience. Even in USA, except for cities like New York and the like, mediators do not earn as litigators in that country. We have first-hand experience when we visited the University of Utah in Salt Lake City. Mediators there are attached to the courts and they make, it was said $10,000, make merely $200 an hour.
Oh.
So therefore, we have this notion about mediators earning huge amounts abroad. But let me now tell you about in India. In pre-litigation mediation, which we refer to as conciliation, since we use Part 3 of the Arbitration and Conciliation Act, in the absence of a standalone law, there are our established mediators in Delhi, which I am aware of, are charging and are being paid an honorarium in 6 figures. And I am a witness to that. So therefore, saying that it is not remunerative in India is not correct. 6 figures honorarium are being paid. It is only a question of time. Disputants needs to trust the mediation process as an appropriate dispute resolution, and I'm sure they'll come to you. I'm a born optimist, and I feel that that mediation has a great future in our country. I'm reminded of Professor Jim Holbrook at University of Utah. He said, mediation has great future in India because while American mediators are settlers of disputes, Indian mediators are healers of disputes. That's the difference. Thank you.
Great answer. Thank you, sir. And coming to the last question to Ram Majid. Apart from advanced training and making mediation professional attractive, from your experience in international mediation, what do you think makes it difficult for international clients to choose Indian mediators? Or asking in another way, what hurdles are there for international clients to have India as a good destination for mediation?
As you know, as I also understand that you are running short of time, so I'll be giving very crisp and short answer for this. See, unlike arbitration, where parties look at the arbitrator's expertise in the substantive and the procedural law of the dispute, that comes for arbitration along the subject expertise of the subject matter of the dispute, the outlook of the parties in the mediation is quite different. So it doesn't matter that whether the mediators originate from India, Pakistan, US, Bangladesh, UK, or wherever, or elsewhere, right? The expertise of the mediator in handling the mediation process in the manner that is acceptable internationally is what matters. So you need to know how to handle the disputes. That's something which I say will be irrespective of any jurisdiction where you are originating. So, and for this, of course, quality mediation training is important. But when I undertake the training, it is something I do to learn the techniques, but how does it helps or give a guarantee to a user that you are good at it? So we need to have an internationally recognized I think in the morning discussion, this has been pretty much clear to all of us that we need to have a standard, we need to have accepted accreditations. And more than that, what I think Anil sir has mentioned about the feedback and the digest. See that if we started making the feedbacks and the digest manual, so it will be very easy for the users to choose you, because there should be some parameter that how just by reading the name, they should not come to you for resolving their dispute. After all, that is their dispute and they should know how to resolve it, and they should choose the correct person as per the dispute. So if the feedback will be there, if the reader digest will be there, the reviews about you will be there, it is easy for everyone, even not only in India, but abroad also. If they want somebody to be mediator from India, they can select after seeing the feedback digest and all. So that practice, I think, should be good, and accreditations like AppCam and all. So that is make it more useful. And one thing I would like to add, what you have asked to JP sirs also, I would like to add one thing that, see, one thing which that is primary attitude right from the policy makers to the court of the lawyers, mediation is primarily viewed as a tool to bring down the court docket. So we need to understand that is the only side effect. When we have a cut somewhere, it bleeds. And you may put the ice cube over it to cure that, but it doesn't mean that the ice cube is only used for this purpose. Ice cube has so many other purposes as well. Yes. So similarly, the mediation is an independent method of resolving the dispute and maintaining the harmony in the society. So it is a standalone profession, but if we give emphasis that the process only as a tool to bring down the docket of the court, then we are moving in the wrong direction.
Yes. So we are coming to the last question that is common to all the three panelists. I hope we have enough time to answer that. Does the legal fraternity in India today see mediation merely as a tool to cut down pendency in courts? How can we change this attitude amongst the legal fraternity in India and bring about more recognition, respectability, and awareness about mediation as a professional and scientific method of dispute resolution as existing global? First to JP Singh, sir.
George, the very fact that seniors in our country, who act as mediators, are doing mediation in court annex mediation centers as pro bono, I think this is a message to the society that this is something which works, and it is not just an alternative to the litigation pending in court. And so therefore I think that is a good enough answer. I mean, we have people who are doing this pro bono. I mean, not that you can't be paid. As I said, we are being paid also 6 figures, when we do conciliations. But so therefore, the fact that we are willing to do it shows that it is a process which is here to stay.
Yes, thank you. Justice Bharara Chakravorti, sir.
No, we have been time and again emphasizing that it is mediation. The only purpose is not to bring down the dockets. We have already been trying to create an awareness even among the members of the bar that world over, as compared to the 130 persons per 1,000 using the court system, in India, very lesser number of persons are only using the court system. So that doesn't mean that we don't have a conflict. And first thing which we say is that by employing these methods, we are only trying to increase the dockets and not reduce the dockets. The dockets which are not coming, which ought to have been in the courts, are not coming to the court's docket. See, our dockets are going to be like they have experts have said that they are going to be like the waves of the ocean. So it will never end. And mediation is one method to increase them and not decrease them.
And Ramajit,
I have already told about it, but the only thing which I say that mediation is a party-centered process and the party-driven process, and it should be like the party will come to the mediation not just to take care of the pendency of the court, but I can adjudicate my matter in my own style. I should have a control over it. That is the first thing, and we have to take it to the community. That's it. We have to take it to the community. Awareness is one thing. Now adoption, we have to take it. We have to proceed from there and pray for mediators and pray for mediation.
so it has been an awesome experience moderating this discussion with three eminent personalities. We all got a wealth of insightful assessment on the quality of mediators and how we can make them internationally competent. Let me express our gratitude and wholeheartedly thank you for and on behalf of the organizers of the seminar, KSMCC, as well as on behalf of all the listeners for their valuable inputs. I'm sure that all of us have benefited from the discussion and enlightened by a wealth of knowledge and wisdom. Thank you all.
Jyoti.
Thank you, George, sir. Thank you, His Lordship Justice Bharara Chakravorti, Madam Iram, and JP Singh, sir, for that enlightening discussion. Well, the pearls of wisdom, some of which we gathered, were that be creative in strategy and know about one's own capacity, connect with them, know the emotions, handle it with care, connect, talk, and walk together. And thanks to all the participants for the words of appreciation you have been putting in the chat box. I'm thanking all on behalf of the panelists. And now we come to the end of our session. And I welcome His Lordship, Mr. Justice Alexander Thomas, the President of KSMCC, to deliver the concluding remarks. Welcome, sir.
I'm sure that this humble endeavor that we have made through this center is an optimally successful one in our long journey from being settlers to healers. Our director has already delivered the vote of thanks, but I think we, the Board of Governors, will be failing in our duty if we do not acknowledge gratitude to all of you from the bottom of our heart. Firstly, let me thank all the eminent panelists and the moderators who have taken all the time to be part of this humble endeavor that we have made, in spite of your busy schedules. Let me thank all of you from the bottom of our heart. Number two, let me thank all the mediator participants who have been part of this program, who have thoroughly attended this session for about from 9:30 up till now. Let me thank all of you for being active listeners, and I hope and pray that this will be a good step in our long journey to understand the transformation from being mere settlers to healers. Thirdly, let me tell you that the fulcrum of this program was organized not merely by the sender, but by a team of mediators that we have appointed under the convenership of Mr. George Merlo. But for their endeavors and but for their successful and sincere cooperation, this would not have come to this stage. On behalf of the Board of Governors and on behalf of myself and the director, let me thank all the members of the team of mediators who have given their best for the successful completion of this program. Fourthly, and not the least, one of the most silent persons behind the success of this program is our director. And let me thank our director, Mr. Johnny Sebastian, for all the good works that he has done for this program. Finally, let me conclude by hoping that we'll be able to organize a second national conference at least by the second week or third week of March 2022, if it's feasible. And if by then the mediation bill is not passed, probably we can have an active discussion on the mediation bill, if that is feasible by then. So let me thank all of you for spending your precious time along with us, and hope we'll be meeting again soon. Till then, goodbye.
Thank you, sir. Thank you, all the participants. and hoping to meet all of you physically in the near future. And I hope God gives us an opportunity for that. And with the words, Kabhi Alvida Na Kehna, I end this program. Thank you all. Thank you.
Okay, then with your permission, let me end the session, Your Lordships.
Yes.
Okay.